And Dawn understands this.
No, she does. Sometimes I feel like the blind leading the blind. Okay, what does that say?
All right, Mr. Howell, are you still there?
Yes, I am, Your Honor.
Okay, sorry, we were just getting started on the computer here. And we're just still waiting for Mr. Graff. I see the prosecutor is here now, Ms. Wilson.
Okay.
I'm sorry, what was her name?
Abby Wilson.
Thank you. I like to put that on the dispo, but I couldn't remember what her last name was.
Hello?
Yeah, is that Mr. Howell again?
Yes, that is me, Your Honor.
Yep, I can hear you just fine. Again, we're still just waiting for Mr. Graff.
Okay, I'll be here.
I think I see Mr. Graff now. Mr. Graff, can you hear me okay?
Yes, good morning, Your Honor.
Yes. All right, and so let's go ahead and get started. This is People versus Matthew Powell, file 215197. And Mr. Graff is here on behalf of Mr. Powell. Ms. Wilson for the People. This is the date set for sentencing. And also a show cause hearing, although I think under the circumstances at this point, addressing the show cause doesn't really necessarily make sense. So Mr. Graff, have you gone over the pre-sentence investigation with your client, and is it accurate and complete?
We have, Your Honor, and we have no additions, deletions, or corrections.
All right, and what would you like to say then on behalf of Mr. Howell?
Thank you, Your Honor. Your Honor, obviously we have a very sad situation here in which we have an individual who assaulted their elderly father. There's not a whole lot that you can say to defend those type of actions, but what I will say, Mr. Howell's defense is I think he understands that this behavior is not going to be tolerated by the court or anyone else. I think there's been a line drawn by the family that they're not happy with him, that this is not going to allow to stand any further. I think we take a look at his record, all his offenses, at least the last couple probably have to do with alcohol. He blew a .291 in this incident. If he doesn't get a grasp on the alcohol issue, he's probably going to find himself back before the court again. We'd ask the court to follow the recommendations. I think he served the maximum penalty on the underlying offense. It's my understanding that Mr. Howell plans on relocating downstate. Hopefully we'll address some of those issues down there. And hopefully this court doesn't see him again. I would ask the court to consider the fact he doesn't really have a whole lot of funds when the court considers imposing any fines and costs. But other than that, we'd ask the court to follow the recommendations.
All right, thank you, Mr. Graham. Mr. Howell, is there anything you'd like to say?
I completely agree with them.
Okay. All right, Ms. Wilson, anything for the people? I think that was a no, but I'm having trouble with both attorneys. There's some feedback we're getting, and we just got a new computer system here that may be the issue. So, but anyhow, okay. This is sentencing on defendant's conviction of attempted domestic violence. And the facts are that the defendant was intoxicated, highly so. PBT showed a 0.29 blood alcohol, breath alcohol concentration. And for whatever reason, he was upset at his 84-year-old father and pushed him over, according to the father, and actually struck him in the back with a closed fist. Defendant admitted to this eventually and said he was really upset. And I'm guessing this probably wouldn't have happened if you hadn't been extremely intoxicated at the time. The reason for the show cause today was a lot of positive pulmonary breath tests and failing to appear for drug screens. And the probation officer did note the defendant seemed to blame others and downplay the assault, and does admit that he has an alcohol problem and hasn't really sought help for it. And the recommendation is time served, given the fact that the defendant is here on a 45-day offense for attempt domestic violence, and he served 40 days as of July 13th. Let's see, and given that there are only 5 days left, typically he would have gotten good time credit for those other 5 days. So this is somewhat perfunctory. The defendant has a prior history that includes 2 counts of assault in 2015. So that this isn't the only assaultive conduct. There's also intoxicated driving in 2001. So the sentence will be credit for time served. As far as fines and costs, since there's no supervision here, I will lower the cost. Fine will be 100, cost 100. Crime Victims Fund 75, judicial assistant fee is 50, and the court appointed attorney fee is $250. You'll need to contact the court to take care of those fines and costs. And I hope that the 40 days spent in jail will hopefully you thought about this some, and it'll make a difference as far as getting some sort of treatment. You've obviously got a terrible alcohol problem, and you need to do something about that if you want to set a different course for yourself. And it's sad to hear that your family sounds like they don't want anything to do with you right now. And frankly, who could blame them? So But I hope if you get some help for your alcohol problem, that could all change. And so I wish you luck with that. We're all set for today then, Mr. Howell, and feel free to sign off at this time.
Thank you, Your
Thank you,
Honor.
Your Honor.
Thank you, Your Honor.
Yeah, thank you.
Jacob. 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 Jacob.
Hello, is that Mr. Howell asking for Mr. Graff maybe?
I was, Your Honor.
Oh, you're gonna have to call Mr. Graff at this point because he's already exited the meeting.
Okay, I will do that. Thank you.
Yep. All right, are you Ms. Winslow?
Yes.
Okay, great. Let's see, you do not have an attorney.
No.
Is that correct? All right. So, this is file 5271, People versus Cindy Winslow. And this is set for a plea this morning. And let me check the pretrial form. Looks like the prosecutor has offered to allow you to plead to a no proof of insurance. Is that what you want to do?
Yes, please.
Okay, so that's a civil infraction. And so the criminal charge would be dismissed. Now, you understand that there will be some fines and costs by pleading responsible to the no proof of insurance, correct?
Correct.
Okay, so is it true that, let's see, on May 28th, you were driving a car and you didn't have adequate proof of insurance?
That's correct.
Okay, and that was in Garfield Township in Grand Traverse County?
Yes.
Okay. And have you gotten proof, or have you gotten insurance since then?
Yes, I actually got insurance within 2 hours of the accident.
Ah, so that's pretty quick. All right.
I hadn't realized that I was involved in an accident. I was driving down and then division and 2 individuals next to me got into an accident and then hit my car.
So what, you didn't get ticketed at all for the accident then?
No.
Okay. No. All right. And did you know your insurance was expired at the time?
No.
Okay. And so this has taught you that you got to make sure that you always keep track of those documents, and it's easy to forget.
Mhm.
But
Yes, sir.
do you have any prior criminal history?
No, sir.
Okay. And is there anything else you'd like to tell me about the offense before I impose the fines and costs?
No, sir. It was COVID related. I had turned off my automatic payments, and that's why I hadn't realized. And so now I've gone through and made sure that I've got it in my calendar when things need to get paid now. So.
Okay, good. All right. Well, I'm going to impose minimal fines and costs. It'll be $50 fine and a $50 cost. Okay.
Okay.
You'll need to contact our court to take care of the payment, and that's it for today then.
I do think we have to add the $40 JSB on civil infractions. It's $50 for that.
Oh, how much is that?
40.
40, okay, and there's a $40 judicial system fee.
Okay.
Okay, so $140, and again, if you could contact the court, let them know.
Okay.
That you want to take care of that, and we're all set for today then.
Okay, thank you.
Okay, thank you.
I'm gonna take a quick minute and run over and get one of those technicians. I'd like them to hear the next.
Yeah,
Just need real
it'd be
quick.
good if you could get a attorney on the line, maybe from the prosecutor's office to show them what's going on. Let's see, no sentences till 9:30 now.
Okay, so I won't have them come back over until 9:30. I'll go get them though.
Okay.
I just need to get them.
All right, so we.
Thank you. How's your summer going?
It's going pretty well.
Good.
Yeah.
So how many days a week are you here?
3 to 3 days a week.
Uh-huh. Well, so let's talk that through.
Okay.
Well, there's a person on, so maybe we can have him talk to us.
Sure. So,
Sir? Sir, can you hear me?
Yes, ma'am.
Can you hear us? So we are just testing this recording equipment because we were getting an echo, so I'm wondering if you could tell me your name, please?
Kenneth Mathis.
speakers, TV. And the TV's all the way up. This should be 0. Okay.
But how can he, so can you tell me your name one more time, please?
Kenneth Mathis.
So now it's quiet, so it's actually in the back of.
Okay, thank you for cooperating with me. We're just trying to figure out why we're getting an echo in this courtroom, so we'll be with you in just a second.
Can
Okay.
he mention?
Okay.
Can he give us tell his name again, or can he talk to us again?
Can you tell us your name again, please, sir?
Kenneth Mathis. Kenneth Mathis.
Oh, that sounds much better.
Yeah. So the reason why it was actually the TV. It was coming both the TV and the speaker. So the TV basically has to be off. That speaker that's on top of that box
is the one, it's where it's coming from.
Perfect. Okay,
So,
excellent. Thank you for that.
Polycom volume, was it like 3/4?
I did not take a look at it. Were you able to, when were you able to look at the recording? Was it fine in the recording?
Yeah, the recording was good.
Oh, we had that.
And I think I still have the recording on, so.
Oh, okay.
Yeah, it was less than half,
There, pause it.
so I turned it up a little bit more.
I'll see right now.
Yeah, if you want to have say something else, I turned
Could
it
you
up.
tell me your name one more time, please?
Kenneth Mathis. Kenneth Mathis.
Oh, that's excellent. Thank you so
And
much.
you can turn it up and down here
Ah,
if you want it up or either way.
that speaker.
Yes, this is the volume control for the Polycom, which is feeding this speaker. So if
Yeah.
you want to turn that speaker up,
Yep.
that
Yep.
volume control right there.
Got it.
Put this
All
back
right.
over here.
Thank you. I
Yeah,
appreciate it.
Okay.
Um,
So with courtroom 1,
So if we take out the speakers in courtroom 1 and they're just not there next week,
Yep.
and until next week,
you're still able to record, but you'll have holes in the ceiling and you might have a wire or two dangling.
I'm not worried about that.
Okay, I know some are very particular, and,
We're not doing hardly anything in person anyway, so
Okay.
that's not gonna be a big deal for us.
okay.
Good,
Perfect.
thank you.
Thank you.
Hey, Buck,
Good morning.
how are you?
Good, how are you?
Good, thank you.
Well, then that being said, let's bring our equipment over. Look, we're not worrying about. You don't have to worry about speakers. You just have to bring.
Ken,
Yeah.
is Haley the 4-year-old's mom?
Yep.
Okay. When the judge left the bench, did he say, are we next up?
He didn't say.
Okay.
Tim Smith sent me, well, I got back to him on the search warrant, and he's supposed to have sent you the.
He did, I already printed them.
Oh, did you? Okay.
Yep.
I'll have to sign the warrants on those.
Do you want these back?
Yeah. So if you can just give me those pages, I'll need to sign them.
Can you want me to grab them right now, or do you want me to do it in a minute?
Well, we'll do it after.
Okay, yeah, I just have them on Amanda's printer.
All right. All right, good morning. This is People versus Kenneth Mathis Jr., file 215-298-FY. And Mr. Lee is here on behalf of Mr. Mathis. And this is the date set for sentencing on the defendant's convictions of OWI and use of cocaine. Ms. Lee, have you had an opportunity to go over the pre-sentence investigation report with your client?
Yes, good morning, Your Honor. Janet Mistley on behalf of Mr. Mathis, and he and I have had an opportunity to review the report. Just a couple of quick corrections. Under personal information, Mr. Mathis is now 33 years of age.
Okay.
And he's not real sure where probation, where the misunderstanding was with the probation agent. He said he did not tell the agent that he does not drink, just that it's a very rare occurrence that he does. And clearly in this case, he had been consuming, and he readily admitted it to law enforcement, as I can see in the police report. So perhaps what I'm requesting is that the report be changed to read that he does not often drink, or probably most appropriately, he rarely drinks or consumes alcohol.
All right, well, I'll add a statement. Defendant states that he rarely drinks.
That
would be consistent with the substance use assessment as well, because he certainly didn't deny drinking in that. So, okay.
And just so the court is aware, that would also be consistent with what he told law enforcement when he was stopped that evening.
Okay.
There's also some confusion where under incident it states or claims that he denied ever having used cocaine. Well, that just he adamantly denies telling her that. Again, that would be completely contrary to what he told law enforcement on the night of his arrest. when he stated to them that he had in fact used cocaine a couple hours earlier. It would be consistent with signs and indicators of the use of cocaine that they had observed in him. So, I don't know if the confusion is Mr. Mathis readily admits that his drug of choice, if you will, is marijuana. So I don't know if, I don't know what's happening there, but again, I'd ask for the change. Perhaps that he states he rarely uses cocaine or something to that effect.
All right, well, that statement struck me as odd because of the 2013 delivery manufacture of cocaine. The statement of the probation officer is he denies that he ever used cocaine, but he had heard of it. Obviously, he'd done more than just hear it.
Absolutely.
But I'm going to leave the statement of the probation officer in, but I will note that defendant states that that he is aware of cocaine and has used in the past, and that again is consistent with the substance use evaluation.
Okay, thank you. So no other corrections, deletions, or additions. And I just have a brief allocution. I think it's going to be important for the court to hear from Mr. Mathis, who I have found to be refreshingly straightforward and honest with me. He has been an absolute delight to work with. He provided information without me giving him any prompting. He is very prompt to return any of my calls or emails. When I inquired of him as to his work history and not in a judgmental way, but I did happen to ask why he was a stay-at-home dad. He is a high school graduate. He did state that, he does do some odd jobs in addition, but frankly, the mother of his child, his significant other, earns significantly more than he does working at FedEx. And in these times when childcare is so incredibly difficult to find and expensive, they as a family made the decision it was best for her to work the full-time job. He stays home with the child, and then when she's available, he does some odd jobs. So he's very devoted to his family. He also provides support for his other children who are with their mother downstate. So I think what's most important in my mind for the court to know is I think that Mr. Mathis will give everything he can to probation, but he also was, again, remarkably honest with me. He's nervous about it because he does not have a license. There are, the court knows, a lot of requirements, and trying to fit all of that in with caring for the child, doing odd jobs. But I'll let him talk to you about that a bit, and you can make your determination what you deem to be best.
All right, Mr. Mathis, is there anything you'd like to say to the court before I sentence you?
Yes, Your Honor. I just want to say I know there's no one to blame in this matter but myself. I just want to be honest with everybody and get this past me and move on with this.
Okay, thank you. All right, so this is sentencing on defendant's convictions of operating while intoxicated and use of cocaine. And the facts are that the defendant was in an argument with a friend, left the home, driving his car, and he was stopped by police in regards to the argument. Someone from the house he left had called the police. And after conversation with the defendant, they determined that he was intoxicated. There was a blood alcohol concentration of a 1.6, about double the legal limit. And there was also a gram of cocaine found in the baggie of the car. There were inconsistent statements made by the defendant about not drinking and not using cocaine, but he had heard of it. But I think perhaps he was minimizing a bit with the probation officer. He was more forthright, I think, with the substance use assessor. And in addition to cocaine, he used Percocet, Xanax at other times in his life. Said that he doesn't typically drink like this, but he was going through some stuff, as he put it, and admitted he had in fact purchased the cocaine that was in the car. So I thought he was forthright with the assessor, and there were several recommendations made. It says here that he is already making positive changes. Reports he hopes to gain a little bit more knowledge through substance use counseling, and doesn't ever want to drink alcohol again, and says he wants to grow up and be responsible. So the defendant comes to the court with a pretty substantial criminal history, although when I really pare it down, out of about a dozen offenses, 3 of them are possession or use of marijuana, and 4 of them are driving offenses. So the most serious offenses here are the 2013 delivery of cocaine, for which he did 3 months in jail. And then there's a receive and conceal stolen property about a dozen years ago in Ohio with 60 days in jail. To the defendant's credit, he does have a high school degree. He's taking care of his 4-year-old son and staying at home, taking care of the child. He's to go to work in the fall, and his son goes to kindergarten. And otherwise, seems to be doing much better than anyway back in 2013, convicted of that felony. So given that the report indicates there are substance use analysis indicates that the defendant could benefit from substance counseling, and given that Mr. Mathis is open to that and wants to, as he says, grow up and deal with these issues, I'm going to go along with the recommendations of the probation office generally. So we're going to put the defendant on 12-month probation. The fine is, let's see, $200, and cost $400. There's $75 crime victims fund fee and a judicial system fee of $100. There's also a $125 arresting agency fee and $22.30 for the prosecuting attorney. And you'll need to repay the court-appointed attorney fee of $650. During the term of probation, the defendant is not to be in possession of alcohol, mind a mood altering substance. That includes marijuana. And I did note that there were several positive tests for THC and then missed tests. And frankly, use of marijuana is not consistent with someone who's trying to recover. You're 3 times more likely to relapse, is what the numbers show. But if you're going to continue to use THC, it would have to be pursuant to a medical marijuana card. Nothing I can do to stop you from using if you have a card, but otherwise, I'm not going to allow it. You're not to use any non-prescribed medications, and let's see, you're to take all prescriptions according to your doctor's orders, and verify prescriptions you do have by giving a copy of those prescriptions to your probation officer within 48 hours of obtaining those. You're not to live where those substances are present. You need to live clean, and no bars or casinos. I'm not going to rule out restaurants that incidentally serve alcohol by the glass, and I'm sure you know the difference. And I would make an exception for work purposes if that came up as a possibility. I don't believe the license suspension applies anymore, so I'm going to cross that out. You're not to behave in a violent, threatening, intimidating, or harassing manner toward anyone, and be respectful of court employees and service providers. Consistent with the evaluation, you're to complete the victim impact panel and the basic awareness group with no unexcused absences, and complete the intake at Catholic Human Services and follow all of their recommendations, which could be just the basic awareness group, but there may be more. There'll be random alcohol testing 8 times a month and random drug testing twice a month. And the probation office may adjust those testing requirements accordingly. There will also be discretionary testing for both drugs and alcohol. And let's see, given that this is, I know there have been THC problems in the past and that you've missed some tests, what I'm going to do is order that there be a benchmark drug screen today. So between 6 and 8:30 at New Directions. And I'm going to forgive any THC that's in there right now, but I need to see those levels coming down and or 0. And if they persist, then there will be a violation.
Yes, Your Honor.
There will be there will be 3 days of community service work. And jail time is credit for time served, which, let's see, I believe was 3 days in jail. Other than that, you need to notify your probation officer of any contact with law enforcement. The primary purpose of the sentence is to provide you with some education and tools to try to stay away from the drugs and alcohol. And you know that's not good for your son to be around that, and for you to be acting out, getting drunk or whatever. And so the goal here is to hopefully have you have a better relationship with your kids and otherwise be successful. So that's it for today. Is there anything else for you, Ms. Lee?
No, thank you.
Okay, well, good luck to you, Mr. Matthews. And you do need to contact the probation office after the hearing today, sometime between 1 and 4 p.m. So make sure you do that, okay?
Yes, Your Honor.
I'll text you the number, Mr. Mathis.
Okay.
All right. Good luck to you.
Okay.
Thank you, Your Honor.
Thank you. Feel free to send me on. Next, we have file 5235 of 2021, People versus Michaela Miller. And Ms. Claxton is here on behalf of Ms. Miller, and Ms. Wilson is here on behalf of the people. This is sentencing on the defendant's conviction of domestic violence. And let's see. Ms. Miller, are you able to hear okay?
Yes, I am, Your Honor.
Okay, good. Ms. Claxton, have you had an opportunity to go to the pre-sentence report with Ms. Miller?
Yes, Your Honor, we don't have any factual errors to report.
Okay, what would you like to say then on behalf of Ms. Miller?
Thank you, Your Honor. Your Honor, as you can see, Ms. Miller is very young. She has no criminal history. I think Ms. Miller was very forthcoming with what happened on the date of the incident. She unfortunately stated that she was off of her medications that day, which we think played a large role in what happened. Not to make excuses though, Ms. Miller fully takes responsibility and does feel remorseful for what happened. Ms. Miller is seeing a therapist weekly, so she's back on the right track. We do think that the deferral is the right result in this case, considering everything, and we would ask that the court follow the recommendations of the deferred sentence.
Okay, thank you, Ms. Claxton. Ms. Miller, is there anything you'd like to say?
No, Your Honor.
How are things going living with your dad?
They're going pretty well.
Okay, have you had any breakdowns or arguments?
No, Your Honor.
Okay, you're taking all your meds?
Yes, Your Honor.
All right, Ms. Wilson, anything for the people?
Your Honor, the people would ask that this court follow the recommendations in the pre-sentencing report, 1 year of probation and a deferral. Thank you.
Okay, thank you. So I am gonna, well, the facts in this case are that the defendant's mother asked her to put some clothes away, and the defendant got upset. She threw a dresser drawer at her mother, and then started tearing up the living room and bedroom, and just generally trashing the living room is what it sounds like. And she also hit her uncle in the head with her hands. She stated that her acting out was because she did not take her medications. And when she does this, this is the sort of thing that happens, and it happens often, and that's what she said. So Ms. Miller, unfortunately, you have some mental health issues, and that's probably true of about 30–40% of the population, okay? And it's all different degrees of mental health issues, but yours is a little more serious, and you need to really take it seriously yourself. And you know, when you don't take your medications, bad things happen. And I'm sure being away from your mom and your uncle right now is, well, it's upsetting to you, and I'm sure they're not happy about it either. But anyhow, what I'm trying to say is lots of people have mental health issues like you, and there's treatment out there. And as long as you're following your doctor's recommendations, going to your therapist, then you can control your behaviors and hopefully be successful. So that's the purpose of this probation, is to give you maybe some more tools and make sure that you're following all of those recommendations. And on the positive side, Ms. Miller's only 17. She's going into 12th grade this year and has no prior criminal history. And other than this, really no reason to think that she couldn't do the probation. I did notice that your probation officer had to call 4 times before she got a hold of you. You know, you're going into 12th grade now. You need to be responsible, make sure you're checking your messages, and if there is something you need to take care of with your probation, you got to make that first, okay? So I am going to place you on probation for 365 days. There'll be no early release from supervision in this case, because this is a bargain struck with the prosecutor's office for 1 year of probation. And let's see, the fine is going to be, I'm going to make the fines and costs minimal in this case. The defendant is a student. In fact, I'm just going to waive all the fines and costs. It doesn't make sense. The defendant is a student. She's probably capable of getting a job, but I'm going to leave it up to her whether she even has time for that, given the probation conditions here and the fact that she's in regular counseling. So we'll just waive all of those. The conditions of the probation are that the defendant is not to consume or possess any alcohol, no minor mood-altering substances, including marijuana. That would be very inconsistent, by the way, with the medications that you're taking right now. And you're not to consume or be in possession of. You do need to provide a copy of all your prescriptions to your probation officer, so they're aware of what they should expect should there be a drug. You're not going to die. Substances are present, so you need to talk to your dad about that. And you're not to reside where there are any weapons present as well. Let's see, you're not to enter any bar or casino. That doesn't include restaurants. You're not to be in possession of firearms or weapons, and you're not to behave in a violent, threatening, or intimidating or harassing manner toward anyone. Let's see, be respectful to all court employees and care providers. You're to attend the AWARE program through the Women's Resource Center, and they're going to give you some tools that will be helpful for anyone who is dealing with anger problems. So you can sit there and fool with your cell phone and that, and just ignore what's going on. But what I'll tell you is you've got to go anyway, make the most of it, because again, these are tools that would help anyone to deal with the anger problems that you have that are affecting your life in a very real way right now. You can't even have contact with your mother. So take it seriously. Let's see, you're to continue counseling with your therapist Ms. Grinder on a weekly basis, or some counselor, and follow all of their recommendations. There will be discretionary testing for drugs and alcohol. We'll be at that park urine screen tonight. That has to be done between 6 and 8:30 at New Directions. You're not to have any contact with Amber Sargent or James Russell. If at some point they approached your probation officer and said that they wanted that no contact lifted, I would consider that, but that has to come from them. And you're not to obviously have any contact with them about that. You're not to go within 500 yards of their residence or workplace. The jail time is 2 days with credit for the 2 days that you've served when you were arrested. Other than that, you need to notify your probation officer of any contact with law enforcement. There's a phone number on the pre-sentence report for you to call. And I need you to call the probation office between 1 and 4 p.m. today. And they're going to go over all these conditions of probation in more detail with you. They'll answer any questions that you have, including any questions you have about the discretionary drug screen tonight. Okay? Is there anything else for you, Ms. Claxton?
No, Your Honor, thank you.
Ms. Wilson, anything else for the people?
Nothing from the people, Your Honor. Thank you.
Thank you. So we're all set, Ms. Miller, and hopefully I'll see you back, or I'll see your case again in a year from now, and I can dismiss or agree to the dismissal because of a successful probation, and you keep your clean record, okay? So that's it, and feel free to sign off at this time.
Thank you, Your Honor.
All right, let's go to People versus Michael Graves. Is that you, Mr.? Let's see, Mr. Graves here. Mr. Johnson, is Mr. Johnson here? Okay, well, that's at 10 o'clock, so we'll come back. Take your mask down. What is your name, sir, at the Kalkaska jail?
Austin Musil.
Oh, okay. And Mr. Hiles is here on behalf of Mr. Musil. That's file 215219. And this is the date for a plea. Is that what your client still wishes to do?
Yes, Your Honor. Yes, Your Honor.
Okay. And I would note the prosecutor is here as well, Ms. Wilson. Is there a plea agreement?
There is, Your Honor.
You want to go ahead and state that for the record?
The offer is domestic violence first with no objection to credit for time served.
So you're not looking for any probation here, just credit for time served?
No, I believe Mr. Muscle is has some pending charges in Kalkaska and has served pretty much all of the sentence that would be imposed in this case.
Okay.
Your Honor, if I may, Your Honor.
Yeah, go ahead, Mr. Miles.
What has happened is Mr. Musil had a domestic violence with the same victim in Kalkaska. His was ordered by purposes of his probation not to have any contact, and this was a violation of that probation. they sentenced him to 90 days in jail for that violation. And he was in jail for 2 weeks before he was sentenced. And then it was a couple of days before I was able to get his bond pulled in Traverse City so that he would be getting, credit. But he does have 2.5 weeks over and above that as a sentence in Kalkaska, and he still has a few days left to go.
All right. Thank you. All right, so that was a correct statement of the plea agreement then, Mr. Isles?
It was, Your Honor.
All right, and you're saying that he has done or will have done more than the 90 days in this case by the time he served his Kalkaska sentence?
No, Your Honor. The reason that we have no objection to time served is that he was serving time in Kalkaska for a couple of weeks before he got sentenced there. And then it took me a couple of days before I got his bond revoked in Traverse City. So he's in the midst of that sentence, and any sentence that you give him will run concurrent with that.
Okay, so do you know what his credit figure is in this case at this time?
I don't off the top of my head, but I'm sure he does.
Okay, Mr. Musso, what do you believe the credit figure is?
I've served 43 days so far, and with the 90-day mark, I have about 33 days left.
All right. Okay, so is that your understanding of the plea bargain as well then, Mr. Musso? You'd be pleading guilty to domestic violence first, and although the prosecutor's not objecting to credit for time served, that would be up to the court to make that decision whether to go along with the sentence bargain. You understand that?
Correct.
Okay, although in reality, what I do makes very little difference because you'll still be sitting on the Kalkaska sentence. So I don't think I could give you any more than what you're looking at. Okay. All right, so has anyone made any other promises to you to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, sir.
Has Mr. Isles answered all of your questions to your satisfaction?
Yes, he has.
I need to go over your trial rights with you, make sure you understand them before I'm able to accept a plea, so please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. You understand all of those rights?
Yes, I do.
In addition, you have the right to testify in a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that right?
I do.
You also have the right to have witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court will order those witnesses to appear if necessary. Do you understand those rights?
I do understand.
And finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial. Any appeal of your conviction or sentence would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear your case. Do you understand that?
Yes.
All right. You understand that you're waiving all of those trial rights by pleading guilty, and that's what you want to do.
I do.
All right. Then is it true that on April 23rd of this year, you were at an address on Bay Hill Drive in Traverse City in Grand Traverse County with Strauss Magdalena Katharina?
It is.
Okay. And is that someone you had a dating relationship with?
It was, yes.
All right. And did you make an assault on Miss Catherine?
I did.
What did you do?
I pushed her out of the way to get out of the room.
And I take it that you weren't acting in self-defense, and that would have been offensive to Miss Catherine.
No, Your Honor. She just took all my things, so I wasn't able to leave. So she was like blocking the door, so I couldn't leave. That's the only reason I pushed her to the side.
Okay, but it wasn't necessary for you to push her to the side in self-defense, correct?
Correct.
All right. Okay, then, to the charge of domestic violence, how do you plead?
Guilty.
All right, I'll accept your plea, find it's voluntary, accurate, and understanding. I will need to set this out for sentencing because of the Crime Victims' Rights Act, 10 days. So that the victim has an opportunity to appear at the sentencing.
I'm sorry, August 5th at 9:30?
Okay, so August 5th at 9:30, and rather than a pre-sentence report, I would like just a no pre-sentence report, whatever they call those.
Mhm.
Is there a name for that?
I think it's just a criminal history.
Criminal history. Let's see, is there anything else for you today, Mr. Isles?
No, Your Honor.
Ms. Wilson?
No, Your Honor, thank you.
All right, thank you. And we'll see you back. What's the date again for sentencing?
August 5th at 9:30.
Is that going to work for you, Mr. Isles, August 5th at 9:30?
It is, Your Honor. May I appear by Zoom? May
It'll
I?
be
Okay.
done the same method, okay?
Very good. Thank
All
you, Your
right.
Honor.
All right, thank you, and thank you, Mr. Graves, or I'm sorry, Mr. Musall, and you can let the jail staff know you're all set for this morning, okay?
All right. Thank you.
Thank you.
Thank you.
So I learned from our technicians that we were having the echo because I turned the volume up on the Polycom because we couldn't hear, and I should not have done that. The volume has to be turned up on the speaker, that big speaker underneath the Polycom.
Oh.
And when they're both up, then you get the echo. So the Polycom is turned down completely, and then you can turn up the speaker on the microphone with a separate button.
Okay.
And
So they removed the TV screen in here and replaced it with this, right?
No, that's been here.
Is it?
Yes, yeah.
Why does that look so different? So they're not gonna, I'll have the same TV screen.
You will, yeah. Really the change is here for the court recorder.
That's what I thought.
Yeah, so and the other thing is that the speakers in the room are now not going to be separate. So they were installed, the speakers were installed by the people who built the building and never like incorporated into the recording equipment. And now that's being all in one.
Oh.
And because of the flood that we had in your courtroom a few years back, when they took the ceiling tiles out, they only have this much space. And the speakers that they were putting in are 8 inches and they can only have 5, so they have to order new speakers. So they're gonna do everything that needs to be done. It won't affect anything other than they'll have to come back and put your speakers in, which I don't think will be a big deal because you don't have anybody in your room.
Yeah.
It's not gonna affect anything until we have live bodies in there, and they'll have them by next week. They just won't have them by the time they get your courtroom done in the next day or 2.
Oh, they'll have them in a week.
Yeah.
Oh.
Yeah, they'll have them still by the time they get, because they have to do Tammy's courtroom and then they have to go to legal and Antrim as well. So before they get done up here, they'll have them and they'll have them installed. There'll just be a hole with a wire in your ceiling for a couple days.
All right, thanks.
Little by little.
The affidavit.
Oh, let me go grab those.
So. Well, we were supposed to have an extradition hearing at 10.
And then Mr. Menard, or Trooper, or I don't know who that, Mr. Menard sent you a document to that I printed up.
All right, so I need to send you back those two warrants and this affidavit.
Do I have time to go do that now?
You keep copies of all this too, right?
Sue has all those already.
She does.
I just need these to give her these pages then.
All right.
And then you have that letter. Okay, perfect. Thank you.
So, what do you think of the sentences this morning?
Well, I was just wondering why, if someone is 16, would they be tried differently than somebody who's 17?
Yeah. In Michigan, you're treated as an adult once you turn 17.
Okay.
And juveniles are, they're charged with basically the same crimes, but it's called a juvenile adjudication if they're convicted rather than an outright conviction. Or a juvenile, or an adjudication rather than a conviction. And those cases are dealt with upstairs in the family court probate court. The penalties are, obviously doesn't include jail, but they happen as a facility is the Chihuahua Center over by Cooney. And it's really expensive to send somebody there, but occasionally they do that for really bad offenses. And they really do get rehabilitated there, or at least they make a real effort at it. They have more staff, including therapists and psychiatrists and that, than they have kids that are there. And so they're dealing with people that have committed serious assaults or murder and also criminal sexual conduct, those types of crimes. Now, even someone under the age of 17 can be treated as an adult if the prosecutor brings a special motion to have them treated under the adult statutes. Normally the probate judge has to agree to that, but they don't have to for some offenses like murder and certain criminal sexual conduct crimes. That does happen now and then. They charge a juvenile as an adult. But yeah, I don't have to deal with anyone under 17. And then there's a push in Michigan to change that to at least 18. And some folks want to even move it up to 21 or even older. And we're really in the minority in among states. I think there are only maybe 2 other states that have that treat 17-year-olds as adults. Most of them are at least 18. And I agree with it. It's, you see that girl at 17 and we're holding her to the same standard. She was in 11th grade. And there's a lot of research out there that shows that the brain doesn't fully develop until you're 26. And so a lot of judgment and rational thinking isn't in place until you're at least 26, I guess. So, and that's why they also have something called Homes Youthful Trainee Act for young people who haven't gotten in trouble in the past. They can get a delayed sentence even with a serious case if they're under the age of 26. All right, good morning, Mr. Clark. Can you hear me okay? Let's see.
I think that the gal in the pink shirt is either scheduled to be in Tammy's courtroom. I just want to see what, I think she was here for arraignment, so she may be in the wrong courtroom.
All right, Miss Dominga, can you hear me okay? This is Judge Cooney.
Yes.
Okay, I think you're in the wrong courtroom. You're supposed to be in front of the magistrate. Ms. Stocking, can you give her information to get into the right courtroom.
Are you ready for the information?
Yes.
Okay, you're gonna, you're using Zoom, so her ID is 931-472-5935.
Okay.
Do you have that?
Yeah, it's 931-472-5935.
Yes. And Beatrice Cruz is going to join you there as your interpreter.
Okay. Thank
So
you.
go ahead and sign out, and you're welcome.
Is Mr. Clark still on?
He was. I think he just went off camera.
I saw Mr. Johnson as well. Mr. Johnson, are you still there?
I'm here waiting for something to do.
Oh, okay.
I just
Sorry,
called my,
Mr. Clark.
here he is.
Okay, so, this is People versus Bologna, file 203691 SM, and, let's see, Mr. Bologna is here with his attorney, Mr. Clark. And this is the date set for a probation violation hearing. Ms. Wilson is here for the people, and Ms. Morton for the probation office. So, Mr. Clark, have you had an opportunity to speak with Mr. Bologna, and what does he wish to do this morning?
Your Honor, he's going to admit the violations, but with explanations on each one.
Okay, so Mr. Bologna, is that accurate? You want to admit to the violations with an explanation?
Yes, Your Honor.
Okay, so is it true that you were placed on probation in December 2020 for domestic violence?
Yes.
Deferred sentence. And let's see, as a condition of that probation, well, first of all, you understand you do have a right to a hearing today. Mr. Clark would represent you in that if that's what you wanted to do, and you're waiving that right to a hearing, correct?
Yes.
And you understand that the worst that could happen is your deferral could be lost. You could be sentenced up to 93 days in jail with credit for time served. That's not the recommendation, and I usually do follow those recommendations, but I need to advise you of the worst that could happen. Do you understand all that?
Yes, Your Honor.
Okay. All right, then. Is it, as a condition of probation, you were to take it past preliminary breath tests and drug screens to show that you were not using alcohol or drugs, correct?
Correct.
And it says here on June 10th, you missed your AM PBT and a evening urine screen for drugs. Is that true?
Yes.
And it also indicates that you tested positive for alcohol on June 12th. Shows a reading of a 16 and an 016 and an 013. And it also says you did admit to consuming alcohol. Is that all true?
Yes, Your Honor.
And finally, it says here that you tested positive again on June 24th. Shows a AM preliminary breath test result of 0.007 and then a short time later a 0. Does that sound right?
Yes.
Okay. So to those violations, then how do you plead?
Well, let's first start. Let's explain those, Mitch. Right? Why did you miss the AM PBT on June 10th?
On June 10th, I had my 4 kids with me, single dad, 4 kids, ages 11, 10, 4, and 2. We were running late. I advised my probation officer that I did miss it through email. Didn't receive anything else, went on about my day, my work. Looked at my emails the next day and saw that she wanted me to go in to do a urine screen. So that next day, I went in and did a urine screen, paid the $25.
That meant June 11th, correct?
Correct, the day after.
Right. Because
I did not.
Because she asked you to go in on the 10th, but you went on the 11th.
Yes, because I did not check my emails.
Okay. And then, is it true you started drinking that day on the 11th?
Yes.
Which resulted in a positive test the next morning or some.
Yep.
Well, you started drinking sometimes, is that correct?
Yes.
On the 11th to 12th. And then on.
That was, I did go in, I blew positive. I did write her explaining how I messed up and all the stress I've been and find out my house of 11 years is being sold. And I was just stressed. The kids trying to find somewhere to live, money, everything. And yes, I did mess up and blow positive that day.
Okay. And June 24th, it says you're positive 0.007, and a few minutes later it's 0.00. So
that again, running late. I mean, I'm getting there right before time ends. So I'm waiting on my kids and they couldn't explain it. I told them what I was doing. I was cleaning on cologne, did this. He said some kind of residue or something on the tube. That's why it went away. I don't know. Like I said, there's no answer, I guess.
Right. You had one for a negligible amount followed by nothing a few minutes later.
Correct.
Right. So I don't understand why that be indicated as a positive test, because the confirmation, the second test usually nullifies the first one. If this is a data master charge on a drunk drive or something like that, they would not call that a positive test. They just say it was a confirmation. That's why you do 2 tests for data master. So Judge, my client is going to admit those violations with his explanation. Is that right, Mitch?
Yes, sir.
So you're pleading guilty to those with your explanations.
Yes.
Okay, so is there anything else you want to say, Mr. Clark, before I sentence the defendant?
So Mitch, tell the judge what's going on, like we and I talked about yesterday.
I mean, it's just a lot is going on. I'm not working as much because I can't find a sitter for my 4 kids. I get all 4 kids at the same time every week, trying to find a housing, can't find housing. My son, right now I'm at the Child Advocacy Center because my 3-year-old was beat by my ex's new boyfriend. So I've been dealing with all that lately with the cops and everything. And I'm here now. I almost missed this, but I had to be here for my son.
You're at the Child Advocacy Center as a result of your ex's boyfriend beating up a little 3-year-old. Is that correct?
Yes.
Child Protective Services are involved.
Well, then state police, the courts. I even went to the courts, got a PPO for my 4-year-old. He's been to the ER. Now we're here, so
no,
just a lot going on in my life, and my kids are number one. And like I said, I admitted to drinking that day, and my classes are helping, and I just can't afford all this stuff, and I know I messed up. And
we drinking just that one day.
Yeah.
Well, you broke up, Mitch.
Yes, sorry. I'm just, like I said, I can't even barely afford to do once a day, let alone worry if my electric's on shut off notice. I mean, these aren't excuses either. This is just stuff I'm going through. I'm not trying to make excuses for anything. I did mess up. I own that. And I just letting you know what's happening in my life, I guess.
Your Honor, I would ask you not to keep the delay of the deferred sentence on my client, and not having to do twice a day PBTs as recommended, because that's just going to drive him pretty financially in trouble. Because he's only working like 3 days a week. You know, that's if that. And he's settled down with 3 kids part time. How many days a week do you have the kids?
I get him Wednesday after work till Sunday night, and then the next week is Wednesday till Saturday about 12:30.
And I assume a 3-year-old's not going to go back to his mother.
So that's kind of what our meeting was today, because I have the 3-year-old and 2-year-old with her. So the state police said they're going to go try to find this guy now, because now they got all the evidence. So I know she kicked them out.
What county is that?
Antrim.
Antrim County, I thought so.
But the state police took over the matter out of Gaylord.
So Judge, I'd ask you just give him some leniency, keep the deferred status, and just have him do once a day PBTs.
Okay, thank you, Mr. Clark. Ms. Wilson, anything for the people?
Yes, Your Honor, thank you. We would be concerned about reducing the number of PBTs. Mr. Bologna clearly has a substance abuse issue. And, you know, I understand that he is going through a lot right now, but it sounds like his sobriety right now is going to be even more important with his family going through such a tumultuous time. So we would ask that the number of PBTs not be reduced. Thank you.
Judge, I might want to respond to that. You know, now he's going to have to take a 2 or 3-year-old, put him in the car, take him to PBT testing, and pay another, I think it's $20 a week. Is that what it is, Mitch?
If it's twice, it'll be 30.
$30 a week. So that's just any more.
Ms. Wilson makes a good point, though, given the stressors in the defendant's life right now. The alcohol is even more of a concern. And, you know, I'm looking at incident in this case that precipitated all this, and the defendant was so out of it, intoxicated, he doesn't remember pushing the victim down, punching her in the right eye with a closed fist, and so I understand the financial difficulty. I do want to hear from Ms. Morton. Ms. Morton, do you have anything else you want to add?
I want to go back to when he was told to go in for a discretionary UA. When he missed on the 10th, he was told that day to go in that night. He said he saw my email the following day on the 11th. He did not go in for the UA until June 12th on the PM, not on the 11th. And I also put, put on there the positive PBT on the 24th because that was a last minute PBT. His first PBT was at 8:55 a.m. So that's going in at the last minute, and that makes me suspicious when they test at the very last second. So that's why that positive PBT is in there.
Window? The 6 to 9?
Between 6 a.m. and 9 a.m. Yes.
Okay.
He took that 0.007 at 8:55 a.m. I have concerns with Mitch. He is honest when he's drinking for the most part. I think, as Mr. Clark is saying, just keep his deferral and PBTs the same. I don't know what consequences he gets at that point, and this is not his first probation violation. This is the third time. He's had a verbal warning and then 5 additional days the second time he was in front of you. So I have concerns with his substance abuse and the situation that he's going through right now with his kids. I don't know how to help in that aspect. He is still attending men's, and I think that's important, but I think keeping the PBTs just at once daily is not enough at this point. Thank you.
Okay. I didn't quite understand the situation with the Children's Advocacy and the child and the whole investigation, but I'm assuming we're talking about some sort of CSC investigation relating to the 3-year-old.
No, Your Honor, that's not CSC, it's just the child abuse, from what I understand.
Okay, so some kind of child abuse going on, all right. Okay, so this is sentencing on a probation violation or multiple probation violations for consuming alcohol, missing PBT, missing urine screen. I have the same concerns that Ms. Morton does, that when I see these low alcohol levels in the morning, and testing just before the end of the testing window, typically what that means is you didn't get up in the morning on June 12th and have a drink. It means you got schnockered the night before and sobered up, but not quite enough to beat the test. And as many problems as you've got in your life, and you admit that you drink when you're stressed, alcohol's not going to help with that. Your kids don't need to see you intoxicated. And it's not going to help the situation, you know that. And I have to believe that there is a long and very problematic history with alcohol, given MIP in 05, minor BAC in 06, and another MIP in 08, IBAC in 16, and then this domestic violence where you were consuming alcohol. And you can't seem to stop using. So I'm hesitant to continue you on probation at this point because I just think it's going to be unsuccessful unless unless you really buckle down and try to do something about it. But the testing is absolutely necessary at this point. It's clear to me you're trying to cheat the test by sobering up in the morning. But I do understand the concern about the cost of the whole thing and your reduced hours because of the childcare issues. And so this is what I'm gonna do. I wanna put you on a scram device. You'll be testing twice a day. There is supposedly some money out there for people in your financial situation that would help pay for that scram. And I'll give our community corrections officer a call after the hearing today and see if we can do that. My own opinion is the state should be paying for all these tests, but that's not the way it works and nothing I can do about that. But I can see if there's some funding available to make that scram available to you at reduced or no cost, okay? But no guarantees there. Let's see, otherwise I'm gonna continue the probation, but I do think there has to be some sort of sanction here, and that is gonna be the loss of the deferral. Which I'm hesitant, I'm reluctant to do because I want to give you as much incentive to take care of this alcohol problem as possible, but I'm not sending you to jail today, and we've tried that, but I am going to take away the deferral part of this as a sanction. Okay, so we'll try the twice a day testing. And that's primarily to make sure that this isn't something that's affecting kids at this point either, when you're taking care of them. That's it for today. You'll need to contact the community corrections office or the probation office to set up that scram device. That's an in-home device you can test from home. So the concerns about dragging your kids in to test isn't there, okay? All right, we're all set for today, and unless there's anything else for you, Mr. Clark, or Ms. Wilson, or Ms. Morton.
No, thank you.
Thank you from us, Your Honor. Thank you.
Can we just make sure, Your Honor, that this starts, he has to test tonight, whether it's on a scram or a new direction?
Okay, until you get the scram set up, you're gonna have to test at new directions, okay? And so call right away, and who does he call? Is it the community corrections office, Ms. Morton?
He would call the clerks, Your Honor, in probation.
Oh, the probation clerk, so 922-6899. I'll give that to you again, find a pencil.
Yeah, I'm trying to find a pen here.
Yeah, take your time.
So 9.
You got it?
Yep.
922-6899.
And then I appreciate that, Your Honor, and I'm willing to do twice a day. If they can't help me with payment, do I just stay with new direction then?
Well, they'll discuss that with you, how the payment is done. You do have
That's
to,
all.
So just talk to them, and I'm gonna give them a call, like I say, and see if I can run interference here.
Yeah,
Sharice is watching. She says no need you to call. She's got it taken care of.
Okay, so our community corrections director, Sharice Shively, has been listening in, and she's gonna make that happen apparently, so.
Okay, and that's the only reason why I don't have that device is because I couldn't afford it. Or I would have that device ready.
Okay, all right, well, we're all set for today. Feel free to sign off at this time, but make sure you give them a call, okay? Because you gotta get the device. All right.
Good luck, Mitch.
David,
Beauty of YouTube.
What's that?
The beauty of YouTube.
Yeah.
If you have any questions, Mitch, give me a call. I'll be here for a few more minutes
okay,
at the office.
okay, will do. Thank
Okay,
you.
let's go on to our next file. And is Mr. Johnson here? He was here for a brief moment. Do you know anything about the extradition hearing?
I don't. I've looked in the case and it doesn't look like there's anything like, there's just really nothing other than the fact that the gentleman is nearly deaf and he does not use sign language interpreters. You can only hear if he's standing right next to you. So the recommendation was that all future court proceedings occur in person. And that was, I mean, other than that, it was just scheduled for today's hearing. There was an amended complaint filed on 7/10.
Your Honor, did you figure out Graves? Because I think I have some information if you haven't.
Oh, yeah, that's what we were talking about. Is that, are we gonna have an extradition hearing today? Do you know?
It sounds like he's waiving it. Someone came over to get the paperwork and everything for it.
Okay. Well, we still need to put that on the record. So I did see Mr. Johnson again for a brief moment, and then he disappeared on us.
I will email him and ask him to zoom back in.
So, yeah, if you could stay on the line for a bit here while we try to figure out where Mr. Johnson is.
Ms. Schaub just said she has the orders for the waiver. She had to send them back to Mr. Johnson to make corrections.
Well, I think I've been waiting this morning. I wonder what happened with Petoskey. Was Petoskey adjourned? Maybe Alhart had a step to adjourn a couple things yesterday. Because he's on a trial. I don't see it checked in, so it must have come up with that.
Yes.
Okay, so.
And so did Sean Walker, 11 o'clock.
Yeah.
You signed that as well.
So we just got Somick and Davis, the prelims, and Graves possible.
Correct.
And we're on the formal hearing at 1:30.
Other than I gave you the file.
Oh, that's right. Here it is. So I have I just have to have my tooth checked real quick at 1 o'clock, but I think I'll be back.
Okay.
I'm a few minutes late.
I will come in and let them know if you're not here that you will be here shortly.
Cunningham from the AG's office, did he say he wants me to reconsider the search warrant?
Let me go back to his email real quick and I'll tell you what it says.